John Strohmeyer here with Strohmeyer Law. Today we're going to be going through some of the common questions we get from potential clients about estate planning, probate, and tax law. So you're the beneficiary or not of a will, and you don't like what that will says. How can you challenge that will, and are you going to be successful? So there's no guarantee one way or another that you are going to be successful when it comes to challenging a will. There are so many factors that go into determining whether or not somebody can have a will thrown out or modified. Things to think about. Did the decedent, the testator of that will, did they know what they were doing? Were they being overcome? Were they being pressured to sign something? Did they know what they were signing? You can dream up hundreds of different scenarios in which that person may have not known what they were doing or didn't actually want to do what they said they wanted to in that last will. So as to whether or not you're going to be successful, every story is going to be different. I'm not going to be able to tell you that here. If you do want to challenge it, what should you do? Well, you're going to need to talk to an attorney who specializes in this sort of work. This is going to be specifically probate and trust and estates litigation. Regular commercial litigators, personal injury attorneys, folks who don't focus on this aren't going to be familiar with some of the ins and outs of how probate court works in Texas. You do want somebody who is familiar with not only what a will looks like, but also how the court system works a little bit differently in probate court. It's just not a normal trial in the way that a personal injury suit, a criminal defense issue, or commercial litigation. It's just different. You want somebody who's familiar with that. You're going to want to reach out to them. They'll give you an idea of whether or not you have a chance of overcoming this, changing the will. You also want to be timely about this. Once the will is admitted to probate, the presumption then is this will is valid. You'd want to bring a challenge before it is admitted to probate by the judge. This is not just having the will filed with the county clerk, as is required by Texas law. You're looking at the hearing where the judge bangs the gavel and says, yes, this will is admitted to probate. You want to get your challenge in before that because you're going to have a better chance of overturning it or getting your claims heard before it's admitted rather than after. Thanks so much for watching. If you've got other questions about this, go ahead and leave a question in the comments below. Also, don't forget to like, comment, and subscribe.